All right. Well, good morning and welcome to this Tuesday, October 26th session of the Small Business Bootcamp. My name is Faith Ritchie, and I'm the Small Business Programs Manager here at the ACA, filling in for usual host, Robert Theobald. At the start of these presentations, we always like to acknowledge and give thanks to the many community partners who have made this program possible. We could not provide the content that we do without their time, energy, and expertise. For those of you who may be new to the Small Business Bootcamp, the ACA Small Business Bootcamp was designed to help prepare small businesses of less than 20 employees return from the COVID crisis stronger than ever. It is a statewide initiative supported by our many community partners and is a resource collective and content library. So what is the Resource Collective? The Resource Collective is made up of additional tools and guides provided by our statewide community partners to assist you in running your business effectively. The content library is the collection of our more than 180 recorded webinar sessions covering many different topics, strategies, and tools to assist businesses not only return stronger, but to stay strong. These links will be shared momentarily in the chat. So if you do want to engage with those resources, you will have the links to do so. Now, as always, for the most up-to-date COVID mitigation measures and resources, we always recommend that you visit Arizona's website at arizonatogether.org or visit the COVID-19 webpage on the Arizona Commerce Authority's site. Additionally, the ACA has services and resources available to assist the small business community throughout the state. Whether you are looking to start, grow, or scale, there may be additional resources available to you. For information regarding these programs, the Small Business Services, Arizona at Work, and the Arizona Manufacturing Extension Partnership, you can always visit the Arizona Commerce Authority's webpage. Now, speaking of looking to start, operate, and grow in Arizona, the ACA also hosts the Small Business Checklist, which is an interactive online guide to help answer all of those commonly requested licensing questions for local, state, and federal levels. Now for some quick business updates. As many of you know, Small Business Saturday is the Saturday following the Thanksgiving holiday and was created to highlight small businesses and the impact of shopping local. If you are a business that would find value in that purpose, we will be sharing a link in the chat momentarily to give you some insight and strategies on how to get registered with the Small Business Saturday. Just yesterday, Governor Ducey announced that $3.5 million for programs to support continued economic growth, financial recovery as the state emerges from the COVID-19 pandemic. We will share the news release link in the chat of this most recent announcement, and we'll provide special sessions of the bootcamp to provide additional information and insight as it's made available. Additionally, some updates we will continue to highlight that may be an opportunity for you and your business is the Economic and Injury Disaster Loans Extension. So there have been some updates to that program, and so those links will be shared in the chat. And additionally, that employee retention credit. We have done some bootcamp sessions about this credit in the past. So if you'd like more information other than the link we will share, you can also utilize the content library as a resource. Now for our upcoming sessions. We are excited to welcome back Brian Burt with Snell and Wilmer to discuss the top 10 legal mistakes for small businesses. But on Thursday, we will have a first of its title and topic for the Small Business Bootcamp, Your Business on TikTok. We know we've gotten a lot of interest and asks, especially in our social media sessions. And so we're excited to dedicate a full session to this newer platform, especially for small businesses. Then we'll be joined next Tuesday for a fun presentation of how to handle haters and learn how to handle those challenging, demanding, and difficult customers we may just want a little more insight on how to solve. Certainly not last and least, next Thursday, we will be celebrating our 200th Small Business Bootcamp session. For our 200th session, we will be joined by the Small Business Administration to highlight the SBA's National Veteran Small Business Week. This 200th session will focus specifically on small business programs for veterans that are available to help with their entrepreneurial efforts. Now, finally, for the reason we are all here today, we are excited to introduce Brian Burt, partner and chair of the Emerging Business Group of Snell and Wilmer. We have been lucky enough to have Brian join us for a few sessions in the past, and we always know him to provide some fantastic insights to assist small businesses in the legal lens that many of us are not as apt to doing. So thank you so much, Brian, for joining us. I will go ahead and stop sharing my screen and we'll turn the time over to you.
All right, thanks, Faith. Great to be here again. And everyone see that okay?
It looks great.
All right. Well, thanks again. Really look forward to presenting another installment here of how to avoid the top 10 legal mistakes that can destroy your business. We're going to pack a lot into the next hour or so until 10. So if you have some questions, feel free to throw those in the box, or feel free to reach out to me separately offline. My email is at the bottom of the screen there. So if you want to take that down, and maybe Faith can throw that in the chat room as well. If you'd like to get a copy of the presentation, also happy to give that to you offline, and you can have that for reference. And if you're interested in scheduling an opportunity for a no-charge consultation to chat about any of the things we're going to cover today, feel free to reach out for that as well. Always happy to set that up and talk to you about your particular needs or situation. So with that, again, I'm going to cover a lot of information. If you happen to be on social media and you want to post something, it's Emerging Business with 1S. Always love to get feedback from these programs. Just a little bit of background for those who might not be as familiar with the firm. We've been around for a long time by Phoenix standards. We've got about 450 plus lawyers in our now 16 locations. We've expanded a bit, as we typically do during the kind of moments of crisis, if you will, opening up recently offices in San Diego and most recently in Dallas, Texas. And we're a true full service firm, so all the resources you might need to start, grow, and sell your business. A lot more information available on the website, as well as I post a kind of weekly articles of interest blog for companies that are in the emerging space. So if you're one of those, or like me, you work with entrepreneurial clients, you might want to check that out and get some weekly updates. My role here at the firm is to head up our emerging business groups. I get to work with lots of different entrepreneurs in all shapes and sizes, sometimes coming in kind of a concept stage, other times coming in toward the back end when they're ready to facilitate an exit event, and really all points in between. So today we'll be talking about the things that most commonly see over my career, things that could pop up weekly, sometimes daily, and that can do some significant damage to long-term success of your company. There's probably a number of things along the way that you'll say, hey, why are we talking about this? Seems pretty straightforward, pretty simple. No one does that. And everything on the slides that you're going to see in the next hour are things that, in fact, again, we see constantly. People tend to focus on everything but the legal stuff, and we get it. It's not as exciting to talk to us. You'd rather focus on getting the company set up, launching the product, starting to generate revenue, bring in new customers, all the fun stuff that the entrepreneurial experience lends itself to. Talking with the legal team, not so exciting. So we get it. And in people's haste to kind of get to market and focus on those other things, we see lots of the legal issues kind of go on the back end. And all these things that you'll see today are fairly easy to address. Some cost nothing, some cost very little. It's not like it's a huge investment, but when it breaks or something goes wrong, it can be extraordinarily expensive to fix, if in fact you can even fix it. Oftentimes, when things go sideways, you're kind of locked into that mistake. And we've seen plenty of companies just get taken out completely because they made a mistake at the front end, never corrected it or identified it, and it came back, months or years later to bite pretty hard. So that's the purpose of today's program, to kind of give you a fairly quick snapshot, just in an hour here, of kind of the top 10 categories of things we see. And again, happy to chat with anyone offline if you happen to have some questions as we walk through it as to what you might be doing in your business. So number one, selecting the wrong form of corporate entity. So these are the options that you can select. Very few partnerships are formed these days. So typically it comes down to the corporation or the LLC. The S corporation is simply a tax election to have pass-through tax treatment, and same from a corporate standpoint. We're going to talk probably a number of places today about what I call myths on the street. And these are things that people tell us they think are true. They've heard them from a buddy. They've gotten them off the internet. Somehow they believe they're true, and often they're not true. And people make pretty big decisions from a company life cycle standpoint on the basis of what is often false information. And the first one is that only a C Corp gives you total liability protection if you do it right. And that's just not true. You can be in the S Corp, you could be in the LLC, and if you do it correctly, you still have that corporate shield, which is the reason for forming the company, to make sure that if a claim hits, it doesn't go after your personal assets. I like the LLC to start because it offers maximum flexibility and no corporate level tax, as we're all kind of focused on what's going to happen in DC with the potential tax increases. Always nice to be in an entity, if possible, that offers only one layer of tax and not taxable at the corporate level and at the ownership level. And unless you're thinking about going public, which very few people do these days, that's really the only reason you typically need to be in a corporate structure. There's lots of investors who may prefer that. You may decide ultimately to do that for other reasons. But from a legal standpoint, again, one of those myths on the street is if you're raising capital or doing certain things, you've automatically got to default to a C Corp. And it's just not, again, accurate. You can be in the LLC structure. You can grow the company substantially. You can raise large amounts of capital oftentimes and still maintain that one layer of tax. Like everything we're going to talk about today, the problems don't age well, meaning if you say, you know what, let's put that off until maybe mid-2022, too much going on right now, I want to deal with that later. Typically, the problem only gets worse as the company goes down the life cycle. In this case, as the company appreciates in value, the problem gets worse. If you have to convert, or if you can't do what you want to do down the road with respect to corporate structure, you may lock in a pretty substantial tax bite. And time permitting today, we're going to talk about real life kind of lessons learned, because I think those are the most helpful takeaways for you listening to the program, to understand what's that really mean to me from a practical standpoint as I listened to these various tips. So the first one was a local company that was formed before LLCs existed. So that wasn't even an option. And they were formed in a C Corp. They grew the company. They passed it to the second generation. The second generation could have converted the entity, but didn't do it. Took it as the C Corp, grew it, and we got brought in to help facilitate transition to the third generation. And unfortunately, the company was worth about 20 million at the time. So they'd really grown the company to a pretty nice level, a lot of profit involved for the owners. And we're looking to facilitate, again, that move to the third generation of owners, with the second generation looking to cash out. It was time for them to move on. And long story short, because they were in the C Corp structure and hadn't gone through any analysis of what the other options may be, for example, maybe converting to an S Corp, and doing so with enough time prior to their transition out to take advantage of that pass-through treatment and work away some of the C Corp tax problem, they didn't do that. And there was really no way around the problem for the second generation. They were trapped from a tax standpoint. They had to pay full double level tax on $20 million worth of corporate value that they could have gotten rid of in large part, or perhaps in entirety, had they restructured or elected as status a lot sooner in the process. So just a first real life example, if you're in a corporation or an LLC or an S Corp, or perhaps even a partnership, you might want to take a look as we approach year end as to where you're at, where you're going, what kind of things you're going to be doing with the company in terms of potentially bringing other folks in, raising capital, doing things that companies do along the way, and determining whether the structure you're in makes the most sense for you. Number two, not protecting your corporate shield. So most people assume once we form a company, we file those documents with the Arizona Corporation Commission, whether it's for an LLC, it's for a corporation, we're good to go. If claims pop up, and they will, if you haven't received a claim yet, you probably haven't been in business long enough to make that happen, but it typically will happen. There'll be a disgruntled employee that you have to terminate. There'll be a customer that wasn't happy about something. There's something that's going to pop up. And I always say that the worst case is you want to bankrupt your company and go home. Not a good result by any stretch, but certainly not, certainly a whole lot better than you bankrupting the company and then finding out that your retirement is at risk, your kids' college funds at risk, the house you bought is at risk. You want the worst case to be the corporate shield protects you from those claims from a personal asset standpoint. But just filing articles and being minimally official is not typically enough. You've got to prevent what we call piercing of the corporate veil. And entrepreneurs, particularly in Phoenix here, where things are moving pretty quickly for most companies, often forget about or just don't know about the fact you've got to maintain corporate formalities. Another reason the LLC is a nice entity is because there's not a lot of formalities. It's often really what you create. For a corporation, there's all sorts of formalities in terms of having meetings, making annual reports, certain types of approvals, et cetera, that you need to do to maintain that structure. What entrepreneurs typically fail to get right is maintaining the difference between the company and the personal stuff. For example, they don't set up a separate bank account with a separate tax number. They kind of commingle funds and pay for personal things and company things out of the same account. Eventually, they may formalize it, but often in the early stages, there's really no difference between the two. If that happens, a creditor is going to take the same stance. If there's no difference between your personal and corporate assets, we're going to assume there's no difference between the two, and we're going to make a claim and expect to reach out and grab your personal assets if that claim demands more than the company can afford to pay. So keeping them separate is really important, and keeping those formalities in place is really important. Putting in place the documentation beyond just what's filed with the Corporation Commission is important. And it's not hard to do that. Again, with almost everything we're going to talk about, it's a fairly easy way to get set up. If you haven't done it so far, I think there is, maybe 5 or 10% of companies that we kind of audit as we go through and get engaged by new opportunities that we see have done it right from start to finish. Typically, it's just something that falls away pretty quickly. Second is undercapitalizing the company, which means not putting enough money in to pay those debts as they come due. When you're starting the company or expanding it, you need to make sure there's cash available to pay those debts. You can't hope for revenue, which never materializes, and then you're forced to shut down the company. And unfortunately, those creditors don't get paid. It doesn't quite work like that. So making sure you have enough money, and there's no one size fits all for the individuals. It's really what your company requires. It could require $1,000. It could require 500,000. It just depends on the nature of what you're doing. And finally, hopefully no one's thinking about committing traditional fraud, but this is really comes up more in the sense where people maybe get terminated from an employer. They've got a non-compete, a non-solicit, and they say, hey, I know I'm bound by the non-compete, but I'm going to go ahead and compete by setting up a company and having that company compete. I won't be able to do it individually, but I'll do it vis-a-vis the company. And that's going to get yourself in trouble and put, again, those personal assets at risk. There's also some personal liability that can arise from different positions with the company. I'm going to focus on two real quickly. One is the bad act. If you're doing bad stuff, you're violating the rules, violating the laws, expect to have individual liability. That should go without saying, although there's people who think that's not the case. The bigger one that comes up to bite people is a personal guarantee. Now, there's a lot of situations where you may need a personal guarantee. It could include a loan, it could include a lease. So there may be situations where it's going to be required to get where you want to be. The key is to monitor the personal guarantee and find a way to get off that guarantee when the time is right, not assuming that, hey, the company's doing great, we'll worry about that down the road. The lesson learned, I think, is the most difficult one here on the presentation, or I guess the harshest one. When we had a local business, this was a while back, right before the crash of '08, it was fielding term sheets for a sale of the company for about 60 million. It was going to be a great deal for the client. It was a long standing family business, great folks, and we're finally going to cash out. And there were millions of dollars of personal guarantees that were in place at that time for that business. And the thought was, which we hear quite a bit, look, we're selling the company. Let's not take the time and effort to get the banks involved and get all these guarantees taken care of. Let's just get all that taken care of at closing. We'll close the deal. They'll wire us the difference between what we owe the banks and what you're going to pay us. Everything's going to be taken care of in one easy step. Well, you know where the story's going. So within 60 days, no one expected the market to crash, particularly hit pretty hard in Phoenix. And this was a business in a space that was hit really hard, more than most, in fact. And they went in a very short period of time, a couple months, from potentially selling the company for 60 million to going bankrupt. And then the banks start calling on the personal guarantees. So again, worst case is you lose the company. That's a pretty big loss when you thought you're going to walk away with some big dollars. What was even much worse is having those personal guarantees called and putting the individuals and the owners in personal distress at that point and potentially wiping them out. So just a situation that didn't need to happen. And if you're in that place, again, monitor those guarantees to see when it might be a good time to pay them off or provide some additional capital or collateral, I should say, to get yourself off of those. Number 3, there's ways to structure your company so that you create additional protection for yourself. And some of you may have done this. It involves putting together a parent and subsidiary, perhaps a holding company with some affiliates underneath. Number of ways to do it, but the bottom line is to fence off either areas of risk or areas of value, or both. So for example, for those on the call that might buy or have a building to operate the business out of, that asset may be worth just as much, sometimes more, than the business itself. So why not put that property in its own LLC and lease that property to your operating business? That way, if something happens with the operating company and it takes a hit, that real property won't be part of that. It'll be safe, tucked away in a separate company. And if the worst case happens and the business gets wiped out, it won't impact the value of that real property. Same thing with intellectual property. Tuck that intellectual property away in a separate company, license it to your operating company for use, whether it's a trademark, a patent. And again, something happens, that intellectual property is tucked away in that separate entity. You can also use it from a kind of line of business risk allocation mechanism. So if you're going into a different country, you're going into a different business line that poses a lot more risk, whether from a regulatory standpoint or just the nature of what you're doing, why not create a separate company to operate that business out of? Because that risk may be significantly greater than what your current business is offering. And so you protect the current business and go into the new business without putting the whole thing at risk. There's issues associated with working through that process, but it's certainly doable. We help folks work through that on a weekly basis. You have to respect your own fences, though, just like when we talked about respecting the difference between personal and business stuff. You've got to respect the fences you create. If you're creating 2 or 3 entities, you can't act as though they're one. They've got to have separate bank accounts, tax numbers, operations, etc. You have to have a lease in place if you're leasing that real property in that example. It doesn't have to be a 400-page lease, but something that actually does require economic payments between the 2 companies. So kind of an arm's length arrangement to make it work. So ways to do that, and not that difficult. The lesson learned here, just real quick on this one, this happens to a lot of entrepreneurs where you're in one company and you're deciding, hey, I'd like to do something different. And so I'm going to work on that second opportunity, but I don't have I don't know if it's going to go yet. So I'm just going to work on it in my existing company, and maybe we'll move out those assets if and when this launches. So we had a client who did this where they were building their own second software product in an existing company. They didn't think to move that software out of the company to a new co. They were going to do it in due course. Unfortunately, a claim hit that was actually a class action lawsuit and threatened to take down the existing business. Unfortunately, because the software, which they had spent a couple $100,000 to develop, was stuck in that existing company and now subject to the claims of those plaintiffs who, if they won, would view that software as an asset for them to take. And so the only way to get around this, because the lawsuit was already pending now, was to essentially buy the software from themselves. They could take the software out if they replaced it with enough cash to reflect its fair market value, and that wouldn't upset the legal requirements for the lawsuit that was trying to get at those assets. So this one actually ended on a good note. They had to set up a new co, set up a structure to buy their own software from their own company, which would have ended up costing them twice as much if you would have played this through. Good news on this one is they settled the case. And so they were just paying kind of one hand to the other, and they were able to put that lawsuit to bed and not have to come out of pocket for, again, another couple $100,000 to buy it from themselves. So that one ended well, but there's plenty of situations where the restructuring doesn't happen until it's too late. People come up and say, geez, we got hit. It could be any number of issues, whether it's a lawsuit, it's a regulatory action. And, we wish we would have moved that particular asset over. We didn't. And now what do we do? And it's too late, typically, once the claim is out there, to do it, or at least do it in a efficient standpoint. So if you're thinking about doing it, and you haven't quite got to it yet, it's something great to think about as you launch into the new year. Number 4, probably my favorite. If you have a partner of any kind, you've got to have a shareholders or an operating agreement if you're an LLC. Why do you need one? Because the partner and you will disagree. And for folks on the call who say, hey, I'm just doing business with family members, those are the nastiest disputes we ever see. And I thought I had seen everything until recently, when we just saw an even worse situation kind of crop up. These unfortunately happen when you overlay the family dynamics on top of the business disagreements. It's just pretty chaotic. But even if it's not family and just a typical business partner, there's not, people are not going to get along throughout the life cycle of the company. Hopefully, you're able to negotiate a resolution peacefully, but oftentimes it just doesn't happen. People tend to want different things. Circumstances change, and if you don't have a playbook in place to figure out how do we resolve those issues, the company is going to take a hit and ultimately could go out of business. We've seen plenty of companies just totally flame out because the partners were fighting, and there was really nothing left at the end of the day. That's certainly not where you want to be. For folks on the call who are saying, hey, I understand that the corporation statute or the LLC statute, that's a pretty long statute. I'm sure there's all sorts of default rules in the statute that can guide us if we don't want to spend the time, money, or effort to prepare one of these. The reality is that's not the case. So you may find 10, 20% of the rules out there will kind of cover the issues that typically need to be covered. The rest of it is silent. And the reason it's silent is because it gives the owners kind of a blank slate to put in place with, kind of a playbook that they want to put in place, which is nice. But that's also the bad news. If you don't do it, there's not really much to fall back on. And those rules that you can fall back on often don't operate in an intuitive way. They often give you a result that you're not expecting. So the purposes of putting one of these in place are all the things you see on the screen: aligning expectations, allocating those rights, and making sure when people come and go, and they always will, as excited as they are on the front end, people will, for any number of reasons, transition out of the company. And you want to make sure that happens on an orderly basis. And of course, resolving disputes that will come up. Hopefully, no one's stealing from the cash register. It's really just a business dispute. But even those can lead to lots of problems if there's not a playbook in place to make that happen. There's a million examples that I could give you. I've always got 3 or 4 on the plate at any given time, and they typically get to be very expensive, very difficult, oftentimes to resolve. And that's even before they get to litigation, if that's necessary to get that resolution. And like I said, family members tend to fight just as much as others. I think the one example that I'll throw out here is one that I've used before. And I use it because people assume that, look, there's got to be something in the statute to provide for this resolution. And it just shows you kind of what holes are there. So we had a client who, long story short, was run by a couple of bad actors, let's call them. And those bad actors decided to loot millions of dollars from the company and do so in a way that was illegal, to say the least, and was not only illegal from a company standpoint vis-a-vis their partners, but they were doing things in their particular industry that violated the regulations. And so they were committing what are probably felonies. And you would think, given all that, once you found out about it and called them on the map, that there would be an easy way to get them out. Well, unfortunately, there's nothing in the statute that says, hey, if people are committing felonies, you can just boot them out of the company and take back their ownership. So as you might imagine, the company looked to terminate these two bad actors. They immediately sued the company, believe it or not. And it took a year and a lot of legal fees to work through that process and go through arbitration and finally get the people out. And it was all due to the fact that there was nothing in the operating agreement to facilitate a orderly resolution when that situation happened. That company, interestingly, came back to us and said, you know what, we probably need to update the agreement. We don't want to spend that kind of money, that kind of brain damage to work through it. So we came in, we put the operating agreement, did an amended and restated version, put it in place. One of the first requests we got was, you know what, there's a guy over here who's been with the company. He's supposed to get some ownership. We've been putting it off because we have these bad actors kind of keeping us busy, as you might imagine, for the last year or so. Let's give this guy his ownership. So we did that. And this company had some bad luck. So within a fairly short period of time after this guy who had been waiting patiently got his ownership, we found out that guy was also looting the company. The difference was that the second time around, it took 1 day and no additional legal fees to get him out, because it was very clear in the agreement, you do bad stuff, you forfeit your ownership and you go on your way. And so that was just a pretty clear example and comparison between what happens when you have no agreement versus have one that takes care of the traditional issues. So can't encourage you enough, if you've got a partner or when you will have a partner, put in place that rule book on the front end. Number 5, probably my second favorite, raising capital legally. So here in the Wild West, that is Phoenix, folks tend to raise capital for startups, which is great. You've got to have capital to move things forward, but people don't pay as much attention to, or oftentimes not even aware of, the state and federal securities laws that govern that capital raising process. And so if you get this wrong, it is a felony. That's not something that you want stapled to your entrepreneurial resume. And we do separate presentations on this. In fact, we've got a couple coming up I'll mention at the tail end, and you're welcome to sit in on those. They're free programs as well, and get a more in-depth look at how the process works. But suffice to say that when you start having conversations with people or put out there to the public that you're raising capital, whether it's on a website or otherwise, you're kind of in the regime and you've got to follow those rules. And there's all sorts of things that that you need to do to make sure that offering is legal. But bottom line, there's what we call exemptions to registration, and just think of it as a legal path to raise capital. And there could be 2, 3, 4, 5, 6 different options that are available to your company, depending on the facts and circumstances that you see on the screen there, how much money you're raising, what type of investor you're soliciting from. You may have a variety of paths to pick from. The goal is to pick the path that's most likely to lead to success for you, obviously keeping it legal, but also picking a path that is going to be the most productive in terms of bringing those dollars in and bringing them in on terms that make sense to you. So I encourage you to, of all the things we'll talk about where cutting corners may cost you money, may put the business at risk, may put you out of business, this is one of those of today's discussion that you really want to pay most attention to if it's applicable to you. And there are lots and lots of myths on the street that we could talk about for the rest of the time here, and we won't. But there's a lot of people who think, hey, I see stuff on social media. They must be able to do what they're doing. And I can tell you, there's lots of people doing it illegally. And so just because someone you've heard of or a buddy throws something up on LinkedIn and is going about capital raising that way, doesn't mean it's legal. There's also lots of websites and companies claiming to help others raise capital as intermediaries. A lot of those folks are doing it illegally. So if it's something you're interested in, I would encourage you to check out one of those upcoming programs and figure out how to facilitate the process and do it the right way. Number 6, failing to protect your intellectual property rights. And we've got one question on the last slide. I'll answer real quickly. What's meant by offered but not sold? So if you are going out and asking people if they are interested in potentially investing in your company, that's the offering stage. So when if you post something on your website that says, hey, we're bringing in investors, that's an offering. If you are making phone calls to family and friends that may be interested, that's an offering. If you are doing an interview and you state to the newspaper and it appears in the article that, hey, we're trying to raise capital. Well, now you've gotten that offer out to thousands or tens of thousands or hundreds of thousands of people that read that newspaper. So the offering phase is when these rules kick in, and depending on what path you pick, that will determine what is legal and what is not legal. So the whole point is, before you start having conversations or posting anything publicly, that's the time to make sure you're doing it the right way. Second question, is it illegal to give stock in exchange for joining a company before revenue is being generated? So no, there's legal ways to incentivize folks and bringing them in, whether it's a stock option, whether it's a profits interest in LLC. There's a variety of ways to do that legally. Typically, it's under what we call Rule 701, which is a nice way to do that. But the question is gives rise to a good takeaway. Anytime you're giving out a piece of your company, whether it's to raise capital, it's to incentivize employees, or otherwise, you've got to comply with those federal and state securities rules. And there's different paths to doing it depending on what you're doing. But the answer is no, it's not illegal if it's done correctly. So number 6, failing to protect your IP rights. Every company has intellectual property, and it might not be a patented widget. It could be the brand. Lots of companies sell products that lots of other companies sell, and there's lots of competition, but your brand and your customer experience is what is going to drive business to your particular products and services. And so protecting that brand is really important. Other companies may have a proprietary way of doing things, a proprietary formula or process, and that's kept as a trade secret. You keep it confidential. No one else knows how you put that product together or how you deliver that service, and that's what sets you apart from the competition. Encourage folks who haven't done it to kind of go through an IP audit and figure out, what kind of intellectual property do we have or will we have, and then figuring out how do we make sure that we own it and protect it. One of the things, and this happens in a lot of areas of law, it's not intuitive. So if you go out, for example, and hire a consultant to build your website, and you don't get the proper legal language in there to assign that work product to you, then the default rule is typically that consultant owns that website. Even if you paid for it and think it's yours, it may not be. And that catches people by surprise. They assume we paid for it, it's ours, we own the stuff, and that's just not the case. So figuring out who you're going to be interacting with from an employee, consultant, founder, partner level, and how they're going to be contributing to that intellectual property, and then buttoning that up with appropriate agreements. There's lots of ways to do it. One of the myths on the street is that some of these things are not enforceable. Here in business-friendly Arizona, you can enforce appropriately drafted non-competes, anti-piracy, protect people from soliciting your customers or your employees, making sure things are confidential, etc. So there's ways to do it and do it correctly and sleep at night knowing that people aren't going to run off with your stuff if they decide to leave the company or partner with someone else. There's also lots of non-legal ways to do it in terms of restricting data and so forth. Again, things we can't cover in detail for time's sake, but I would encourage you to look into that. The lesson learned here is simply a brand that a client didn't protect a little while back. Probably would have cost them a few $1,000s to file the trademark and get that locked in. Didn't do it, went to sell the company and found out the hard way that the purchase price was going to get a huge discount because they weren't able to transition that brand in a way that the buyer thought they should. And so instead of spending a few grand, they lost several $100,000 in the sale process because the buyer again just couldn't get comfortable that they could then port that brand and take it national in the way they'd hoped for. So they still bought the company, but there was a hefty discount. And again, when you look at the cost benefit of not doing it right on the front end, it was pretty substantial. So everybody is aware, or should be aware, that we're in something called the Great Resignation. This is one of the many statistics I've seen Who knows where that percentage is these days? It may be 99%, but it is a totally unprecedented era that we're in. And the goal would be, of course, to make sure that you are handling employee issues properly. This is one of those many areas that doing something seemingly harmless can cost you pretty dearly in the process. There's ways and lots of rules, unfortunately, that govern both at the federal and state level how to bring people onto the team, how to incentivize them, how to pay them, how to do bonuses, how to dole out vacation. And on the back end, when you're unfortunately having to terminate someone, how should that work? And so I would encourage you to understand what employees want. And there are lots of things these days that are in flux in terms of, are you going to be working at the office or having some hybrid model? How are you going to be constructing those bonuses? Is it going to be performance-based or something else? How do you think about giving people incentives to stick around as you grow your company and sell it? 3, 5, 10 years down the road? Is it going to mean giving out ownership, or is there some bonus structure that you can put in place to do that? So the good news with 92% or whatever it is of people looking for new jobs is there's lots of ways for you to potentially attract key talent from competitors that you've always wanted to tap into. Obviously, that's the downside as well, because people are trying to cherry pick your best team members. So figuring out what folks want, and it's evolving. The younger crowd clearly wants some different things than the older crowd, and no right or wrong answer. It's just a question of understanding how to position what you're offering and do it in ways that are going to be most appealing to different constituencies that may come and work for your company. Other key areas to pay attention to, is an employee properly classified? So as a person who is, being deemed an independent contractor, can they be an independent contractor? And there's rules that govern that. It's not just what the two parties agree, it's what the rules say. In California, it's almost impossible to have contractors these days, given some new rules that have been put in place. Arizona, you still have that opportunity, but again, it has to follow the rules. And so we see, 70, 80+% of employers get it wrong. We do audits and discussions with people all the time who like to treat people as contractors. It's easier. You don't have to do the tax stuff. But again, the consequences of doing that can be pretty catastrophic if you get called on. And it's not hard to get called on. It just takes one disgruntled employee to turn you in, and they come in and audit and determine you've been doing it wrong for the entire team. Once you do hire somebody, people like to put people on salary. Hey, if I've got to hire the person, let's give them a flat salary, make them work as much as we need to. Again, there's rules that govern whether they can be salaried or have to have an hourly rate and track those hours. Again, do it wrong, and you may find yourself on the back end of a pretty unpleasant employment claim in a way that, unfortunately, in the employment arena, if you get something wrong, they really don't want you to do that. So there's ways that they can triple damages and make a small claim turn into a pretty big claim pretty quickly. And so again, it pays to get it right on the front end, or figure out if it's not right currently, how do I get to that point? And goes without saying, there's probably no issue hotter right now than something that would fall into a discrimination or harassment category. And so you want to make sure the workplace is as zero tolerance as possible. And folks always ask, I can't prevent some joker from doing something they shouldn't, which is true. But you can make sure the environment is set up in a way that discourages that, of course. And there's procedures in place for doing an investigation and making sure if something happens, it's quickly dealt with. That can help limit liability from a company standpoint, you as an owner standpoint, and certainly, create an environment that doesn't tolerate that. So there are steps that clearly you can take to help reduce the likelihood that happens, or if it does, ways to deal with it. The lesson learned here, I'm going to skip to the next one, but anyone who's been involved with one of these lawsuits knows how expensive it is to deal with. And not much has to happen for the dollars to get pretty big. So it's something you really want to protect against. One claim can kind of knock you out of business if you're a small company pretty quickly. And you don't want to see all that hard work fall away. So make sure that you do the things you need to incentivize the employees, manage those issues, follow the rules, and create a good workplace. Commercial contract best practices. So everybody on the call who's got a business has to deal with contracts. It's an inevitable part of the business. Everyone's got to do something with those agreements that come in. And oftentimes we see people get frustrated. It's not what they do. They don't like to read contracts. They would have gone to law school if that was the case. And so they do their best to understand what they're signing, but then they go ahead and just sign them. And we see all sorts of agreements floating around when we come in and again are asked to take a look at them or do one of these audits. And we see people, frankly, signing up to things they have no idea what they've signed up for, or they may borrow, for example, a form. They say, hey, I'd love to have a customer agreement. And they borrow one from a buddy who has one available. And we've seen people take those forms that were meant for the opposite side of a transaction and make them their own. And so when we go in and say, well, why is your limitation of liability uncapped, but your customer has a very small limitation? Well, I got the form from a buddy. Well, was the buddy the customer in that situation, or was that person the service provider? Well, he was the customer. Well, you just borrowed a form and have been implementing it for years. This just happened recently, where all the protections are on the customer and you're on the hook for everything. Again, person had no idea that that was what was in the contract, but they had given it out to hundreds of customers. Fortunately, no claims so far, but obviously, was sleeping well at night, not realizing what was baked in there. The best, most efficient way to deal with contracts, which again, most people don't want to deal with, is to create your own forms and have those available when you hire people, when you go to customers, etc. Have your own set of forms with terms that you're comfortable with that protect you but are still friendly and market appropriate. And that will save you countless time, money, legal fees, etc., versus having to deal with the other side's form and process that each and every case. Typically, the way I think about it is the cost of doing it right on the front end, creating a form, you'll burn those dollars up by trying to work through and bring in your friendly neighborhood lawyer on one or two customer agreements. Well, it'll have paid for itself probably and then some, versus just doing it right on the front end and putting your own form in place that works for you. So you quickly make up those investments on those things very quickly. You got to update them. Things change constantly. It's not like every week you need to go back, but at least once or twice a year, call up whoever you work with to put it together and say, hey, what's changed? What do I need to think about to as I go forward? For example, we had a woman that we worked with years ago. We put an employment agreement in place that had a non-compete and some other things in it protecting the company. Well, the rules have changed in the last 8 or 9 years a bit, tightening things up, requiring certain things to be in there, and hadn't updated the form. And there was someone who was a potential flight risk in terms of a competitor, and we had to say, hey, we haven't talked to you for a while, and the form needs to be updated before something bad happens, because the current language again is dated and may not quite protect you in the way that you thought you would. So make sure you kind of put that on your calendar to at least do a once a year update or review. There's ways to process contracts efficiently, whether you have your own form or not. And it's really important to understand that all these things in there, and obviously for time's sake, we're not going to get into them, but at any place in your contract, it only takes a sentence or two, and you don't know exactly what that's getting you to agree to, that could generate a fairly large claim. I'll give you a quick example in terms of one that we see quite a bit recently, and that's in the area of data protection or data breach. And there's things that are being put in contracts to protect against that, or at least to make the company on the hook if it's taking its customers' personal information, credit cards, etc. The average claim can run into the millions if there's a breach. Certainly can put any small business out of business pretty quickly. And it only takes a line or two in the agreement to put you on the hook for that. And when you see it, it often sounds pretty reasonable. You're going to protect your customers' data. That sounds reasonable. Of course we will. But having it in there the right way, having it qualified the right way to make sure that your damages are limited as opposed to putting the entire company at risk for one of those situations, that's all the difference in the world right there. So making sure that in each and every case, you know what to expect. If the worst case happens with this particular relationship, be it a customer, a vendor, employee, etc., we know what to expect if things go sideways, because sometimes they unfortunately do. And that you can get out of that relationship, if not unscathed, at least what the damage potential will be, the risk exposure, and you can walk away from that. Number 9, anyone who's been in litigation or arbitration probably never wants to be there again. And so here are all the reasons why people fight. It is often the emotional component that tends to cause these fights. I can't tell you how many times we've got 100 litigators here in the building, and I don't do litigation, but have to loop in my partners every now and then when it gets to that point. And the emotional piece and the last one you see on the screen there, kind of doing business with unethical people, are some of the leading causes why people go to war against each other. And encourage you to be able to identify and help your team identify when things could go sideways, or take steps to ensure that they don't on the front end. And the things you see on the screen are the most common things I see as reasons people tend to fight. And some of these, frankly, most of these are readily avoidable if you do business the right way, you set up properly drafted agreements, et cetera. Again, you kind of put those rules of the road in place before you get to that point. All these are the strategies to, we won't go over all these for time's sake, but strategies to help you avoid what could be a company ending lawsuit. And again, anyone who's been in litigation, arbitration knows that it's not just the legal fees that you pay, it's the emotional toll that it takes. Oftentimes the folks who are involved with those say, hey, that's worse than having to deal with the money we're paying and settling and all that. It's just the stress and the brain damage associated with that whole process, which can last years. And we wish we hadn't jumped into that. So I'm a big fan of taking informed business risks. There's going to be business risks no matter what company you start and try to grow, big or small. And the things that we're talking about today and all these slides are things that you can control. You can take what are in most cases fairly easy, inexpensive steps to eliminate or at least heavily mitigate those business risks. And that way you're left with things that you can't control. And there's plenty of those. So why not deal with the things you can control and reduce the likelihood is that you're going to have to deal with, pay for, or end up closing up shop because of something that pops up. Doing business with good folks, making sure that you document expectations, whether it's in a contract, obviously that's preferred, but even outside the contract, making sure you don't make promises, your team doesn't make promises they can't deliver on. And perhaps the most important tip on the slide here, make sure that you understand folks on the other side may not be behaving rationally as that dispute evolves. And those can be the most dangerous individuals. People assume, well, geez, we're fighting about X amount of dollars. What if I just pay that person X amount of dollars? They'll just go away. If we ultimately agree to that. And sometimes that's not the case. Sometimes, and lots of times, people get so emotionally invested in the dispute, they think they've been wronged. They think they've been cheated in some fashion, or you're not doing what you said you're going to do. And that it launches World War III. And they spend, and that's why our litigators stay busy. They'll spend, in some cases, more money than the dispute is worth because they feel it's worth fighting the battle. And that's not a place you want to be. You don't want to be on the opposite side of someone who's willing to spend whatever they can afford to spend fighting you, even if the dispute could have been resolved for a fraction of that. And sometimes the dispute isn't even what people think. People tend to send out, in our age of electronic communications, texts and emails and all sorts of stuff that they probably shouldn't. They don't pause, they don't sleep on it, they don't take the weekend. And we see all these crazy communications, and it really, at best, it's not getting the issue solved. It's just inflaming it. At worst, these are the communications that pop up in a courtroom and certainly don't make you look good and help build credibility when you're trying to resolve that in front of a judge or jury. So I encourage you to take steps to try to avoid getting into that situation. Next slide is our last tip, and then we'll kind of wrap things up here. Not planning for an eventual liquidity event. So what probably the most tragic thing is when people start and grow businesses with no end in sight. They don't know what the game plan is. Are they going to grow the business and sell it? If so, when and what value they hope to get out of it? Do they plan to transition it to the next generation? If so, are the kids even interested in the business, or how's that going to work? If they're going to transition it to the kids, how do they get value as the founders, as the parents out of that business? Because no one oftentimes is paying for that value. They're just giving it to those kids. There's lots of issues to factor in. anyone who's been through the entrepreneurial cycle knows that you sacrifice lots of time, effort, family occasions, etc., to kind of get to the goals. And assuming that you make it, then you want to make sure that all those sacrifices pay off. And they can't pay off, at least in the way that you hoped, unless you have some game plan. So if you don't have a business plan in place to understand what those objectives are, and particularly if you have a partner, there's lots of times we see two partners in business for years together, and neither thought to talk about what that next step would be, what that ultimate goal is. Do we sell it? If so, when? Do we pass it along to the kids? What do we do with it? And people will get into business 5-10 years down the road and just start to have those discussions. And you might imagine that creates a fair bit of stress when they find out they're not on the same page. And it's really too late to kind of start over because they're a decade into it. And what do they do next? So I encourage you to think about what your exit event looks like. When is it? What do you expect to get from it? And what the value is you're trying to extract from the business. Folks tend to inflate what they think their business is worth pretty substantially. They hear what their friends sold their company for. Maybe it was a totally different company, totally different industry, different way of valuing that company versus what they're doing. And so they just latch on to that. And probably the most tragic thing is when someone's been working the company for a lot of time and finds out that when they go to sell it, it's worth a third or a fourth or a fifth of what they thought they were going to get. And then they've got to go right back to work again. We've seen people do that who are in their 60s, who thought this was retirement. They totally misaligned the expectation. They just didn't do the research to figure it out. And they find out, again, what they're selling it for is not what they hoped. And so they pay off some debt and they go right back to work. And that's not what they thought after 20 years in the business they'd be doing, but that's unfortunately the results. So do put a plan in place. Get a regular legal checkup. As I mentioned, things change and ways to do that. One thing I'll throw out for the group here on the call, always happy to work with folks to kind of take you through that legal audit process. Depending on what there is to do, oftentimes it's a free thing that you can go through. If there's a substantial amount of stuff, there may be some charges, but to the extent that you're interested in talking about what that might look like, shoot me an email or give me a call offline, and happy to do that. That typically is designed to identify all the areas of exposure and kind of give you a checklist to be able to walk away and say, look, here's the 5 or 10 or 20 things that you might want to think about taking care of in 2022, so that you can get your company on a solid foundation and avoid some of the potential damage that could occur if these issues present themselves. So with that, let me wrap up. I know we've got about 1 minute left. Here are some other upcoming programs. I post all these on that website, that personal website you see at the bottom of the screen. So check that out. It's constantly updated. There are a couple on the raising capital. If you know of anyone that missed today's program, that'll be coming up live again in December. And finally, we are back live at our Emerging Business Seminar. I know some of you have attended that here on the call today, and we're now in our 13th year. We're back live at SkySong after 18 months virtual. So we encourage you to come to check us out again, and love to see you in person. How to Sell Your Business, part 2 of 2 is coming up on November 3rd. And again, all those sites all those seminars are available on that link, so you can check that out. If I've missed any questions, I know we've got to wrap up in less than a minute. So I would encourage you to shoot me an email or give me a call or schedule an opportunity. I'm always happy to chat with you offline and make sure that you get those answers. So with that, I'll turn it back to Faith. Thanks again for letting me present today. I hope you got some good information out of it and enjoyed today's program.
Excellent. Thank you so much, Brian. Always great information that you share. Brian's email has been shared in the chat. And as a reminder, today's presentation and recording will be available on our webpage. So thank you all so much for joining today. And thank you again to Brian. We look forward to seeing you all back here on Thursday to talk about our next boot camp. Have a great day, and we'll see you then.